such person during delivery of mental health care and services. So to protect, promote, and fulfill the rights of such persons, this term was taken from CRPD, because that was considered to be the aim of that convention, and we being the member of that convention, we had to adopt the laws that was in tune with CRPD. Okay, so with all these things, we came up with this law. Now, under this law, there are number of provisions. It's a very lengthy law, we may say. There are almost 120 sections. And when we are talking about mental health law at present, the law is not just in the text of Mental Health Care Act 2017. The rules were framed under this act, and the rules were framed from time to time. Okay. And along with that, there are certain authorities created under this act that have laid down the regulations. So when talk about mental health care law, it's Mental Health Care Act 2017. The rules laid down from time to time and the regulations laid down by the authorities from time to time. This is the legal framework of mental health care at present in India. Okay, so you can see here from this figure that there are so many such provision. The preliminary part talks about why we have introduced this law. Next part is about definitions. It's very important that this definition clause or section 2 of this act speaks about what are the various kinds of professions that are allowed to practice under this act, and that has been extensively discussed, laid down under this act. What is mental health, that is been defined here. And apart from that, for the first time, a new provision that has been introduced and that is considered to be a very progressive step taken up by Indian legislature was the provision of advanced directives. In the same year, there was the judgment of Common Cause versus Union of India, whereby the provisions whereby the passive euthanasia, we can say, was allowed legally, and in that case the advanced directives terms was used by the court, and the guidelines in that regard were laid down. Taking note of such advancements, we also introduced the similar kinds of provisions under this act. Rather, at present, this is the law that has taken note of such developments taking place in India. Then there are provisions for nominated representative. If I write down who can write advanced directives, when can that be written, how it has the legal effect. In that case, if someone writes that and the time for execution of it comes, then who should take the decisions in that regard? Okay, such questions were answered by this law, and there are provisions regarding nominated representatives. There are further provisions regarding what are the rights of the mentally ill person. Then there are further provisions about overall mental health establishments. Then there are provisions regarding the admission, treatment, discharge of the patients. There are provisions regarding mental health review boards. I won't be able to discuss all these provisions because the time won't permit me. We are giving more focus on the question answers and the discussion. But you can see here that there are various provisions that overall seek to provide a kind of dignity towards the mentally ill person. At the same time, overall, if you see the design and approach of this act, you would find that the rights-based approach is taken up by this law. Whereas earlier act was focusing more on healthcare establishment and their regulation, here more focus is on rights of the patients and creating the ecosystem in that regard. Once you take into consideration this aspect of the law, perhaps many of the things that may come as questions in your mind perhaps would be answered. Okay, so you can see here what are the various concepts recognized or defined under the act. Mental health care. What is that mental health care? Okay, that includes analysis and diagnosis of the person with mental illness and treatment as well as care and rehabilitation of such person. Okay, so this was the concept when it is said that it is Mental Health Care Act. The earlier was Mental Health Act. Here the word used is Mental Health Care Act. Then mental health establishment, for the first time, it has taken a broader approach that it is no more restricted to modern medicine, but it includes even Ayurveda, Yoga, Naturopathy, Unani, Siddha, and homeopathy establishments also, either wholly or partly, meant for care of persons with mental illness. Okay, where the persons are admitted or reside at. So all forms of such healthcare establishments are included, general hospitals or general nursing homes, wherein such kinds of patients are admitted for treatment, also now come under the category of mental health establishment, except family residential place where the treatment is given, that is not considered here. Then mental illness, you can see here, a substantial disorder of thinking, mood, orientation, memory. Okay, so various kinds of behavioral patterns where there is disorder also become a part of mental illness. Then various kinds of professionals that are recognized. What are they? You can see here, because a variety of professionals, it seems, are here present in this meeting, including the law professionals. So for all of us to know who all are here entitled to be registered and practice under this act. So professionals recognized are clinical psychologists, medical practitioners, mental health professionals, psychiatrists, mental health nurses, and psychiatrists. Again, the definitions have been given as to who all are included. What is clinical psychologist? Who has a recognized qualification and who has been registered with RCI. Okay, so the educational qualification of them also is being given. So they are recognized here. Then medical practitioners who possess the recognized medical qualification under the concerned regulator, when they have been registered and when their degrees are recognized, they are considered to be medical practitioners. Mental health nurse, this also is being defined. Mental health professional means a psychiatrist defined under this act, or a professional registered with concerned state authority, like say an Ayurveda doctor or a homeopathy doctor, as we have already seen. So those professionals registered under concerned state authority, or a professional having a postgraduate degree in Ayurveda, in Manovignan, and in homeopathy and all that. So these professionals are considered to be the mental health professional. Further, there are some other professionals that are recognized here, that is psychiatric social worker, a person having PG degree in social work and MPhil in psychiatric social work. And psychiatrist, as is defined, it was there earlier also, that a medical practitioner possessing a PG degree and or diploma in psychiatry. Okay, so from this we can make out as to who all are considered here. Then after having seen all this part, let us go ahead to next part. This was the preliminary part of the act, wherein these professionals and various terms have been recognized. Chapter 2 is about the decisions, mental health care decisions, how are they to be taken. And there are various provisions that speak about it. Regarding determination of mental illness, how is that to be determined? That has to be determined according to nationally and internationally accepted medical standards. The determination shall alone not imply or to be taken to mean that the person is of unsound mind. Why is this word unsound mind matters to us? As the legal professionals, we know that the person, when he is of unsound mind, is incapacitated from certain legal rights. For example, he wants to enter into a contract. The contract entered into by him is not fully legal. And there are so many such provisions under various laws. For example, it becomes a ground for divorce also under various matrimonial laws. Likewise, there are various provisions. So here it is said that that the person is mentally ill does not ipso facto make him a person of unsound mind. That would be decided by a competent court. Okay. Next is capacity to make mental health care and treatment decision. How shall that be done? It shall be deemed to a person shall be deemed to have capacity to make decisions regarding his mental health care. Okay, when can that be done? So here provisions A, B, C are saying when he understands the information that is relevant in this regard, or appreciate any reasonable foreseeable consequences of such decision, or communicate decision by any means. Okay, so that is how the provisions have been given. And then it is most importantly seen that a person is not incapacitated just because he is mentally ill. Now, there are many repercussions of such kinds of provisions, which we may address during question answer sessions. Then there are provisions regarding advanced directives. I have already mentioned that such kinds of advanced directives can be made by any person. Okay, I can make it, you can make it, anybody can make it, because they are made in advance. Why are they made in advance? Because tomorrow, in case I become mentally ill and I become such a person which is incapacitated to take the decision, I can't take my decision, I can't manage it. Then in that case, if it is found that I have lost that capacity, then my advanced directives which have already been written can be executed, whereby I have appointed some representative, which is called as NR, or nominated representative. He can take decision on my behalf. What is in my best interest can be decided by him with consultation of a doctor. So there are provisions in this regard. Who can write it, when it will have legal effect, what is the procedure in that regard, where that needs to be registered. A mechanism is created under the Act. Then next is chapter is about nominated representative. So the provisions are there in that regard. So here you can see that this nominated representative has so many responsibilities given by the Act. Okay, you can see here. In case a child is there, then how the decision is to be taken. The child cannot write advance directive. So in case of children, the guardian would take the decision, and how would he be appointed. So for such children, there are special provisions under the Act. So rights and duties have been laid down. I'm not going into the details of it. Now, most important part is about rights of persons with mental illness. What are those rights available? He has access to mental health care. What is this access to mental health care? Because every person has, it was earlier considered to be just a human right, but now it is considered to be a statutory right, whereby he has a right to get all such treatment which is affordable, accessible, available at various places. And then ultimately the question is whose responsibility it is. So we have seen that under directive principles of state policy laid down under Indian Constitution, there are provisions regarding duty of the state to provide all adequate means of healthcare for its citizens. So the duty is laid down upon the state to establish such healthcare institutions at various places. The Supreme Court of India also from time to time has laid down the directions to the state in this regard. Various judgments are there. I'm not going into the judgments at present, but n number of judgments are there where the scarcity of mental health care professionals and establishment has been focused by the court. Then he has right to community living. Okay, because in many cases it has been seen that such persons are kept in isolation, and as a result their mental health condition worsens. So this is considered to be now a statutory right, that they have a right to community living. Protection from cruel, inhuman and degrading treatment. This is considered to be violation of not just human right. Now it has been for the first time recognized to be a statutory right. In spite of that, recently there was a PIL filed in Supreme Court, wherein the Supreme Court has directed the authorities under this act to take the survey of all the states and union territories in India and file a report regarding the status of the treatment of such mentally ill person, because it was observed in many cases that such persons are subjected to cruel and inhuman treatment, like chaining, not giving sufficient health care to them, not giving proper food or medication, and so on. So many are there. Then equality and non-discrimination, that such persons cannot be differentiated on such grounds. There can be gender differences, caste differences, religion differences, differences on the ground of economic status, and so on. So on various grounds, there can be discrimination. Of course, this need not have been here under the law, because the Constitution of India itself lays it as fundamental right to equality, right against discrimination. These are considered to be fundamental rights, but in reality, it so happens that they are still discriminated, they are stigmatized, and that's why the special provision again has to be made in this act. Then right to information. Okay, many a times it is found that such person is not conveyed fully about what kind of illness he is facing, and then what kind of treatment is being given to him. The decisions regarding the treatment are taken by the doctors and somebody else who calls himself as the caregiver of such persons. If the person is institutionalized, some head of the institution, like somebody else takes the decision on his behalf. And this violates the principle of autonomy and, of course, right to privacy of the person. That's why he has right to information, to seek all such information that is relating to his illness and treatment. Then at the same time, confidentiality. What is this confidentiality? That is the basic principle. Now, right to privacy is being considered to be a very fundamental right as a part of right to life. Okay, few years back, there was the case decided by Supreme Court. That was Justice Swami's judgment. In that case, it was decided that it was the full bench judgment of the Supreme Court wherein right to privacy was considered to be a fundamental right. Okay, when it is considered to be fundamental right, should it again be considered here? It was seen that it has remained on paper, especially with respect to mentally ill persons, as they are more vulnerable. This needs to be there included in the act, and that's why it seems that this provision is being included. Then there is restriction on release of information about mental illness. Again, this is based on the right to confidentiality. A very corollary of it is that there is restrictions on the other side not to release this information except certain conditions. Access to medical records. Again, the same thing. When it comes to information, access to medical records. What kinds of records are to be kept by MHEs, that is mental health institute establishments, and then how he has a right to access to these records, and if it is denied, what is the remedy to such persons that is being provided under the act. Then personal contacts and communication. After all, he is a part of the society and he has right to community living. When we say he has right to community living, at the same time, in order to make this ecosystem livable for such persons, such right also is recognized. Right to legal aid, yeah, that is very much recognized. Rather, right to legal aid is considered to be a part of extension of right to life under Indian Constitution. And these mentally ill people cannot be kept away from that. And that's why it is being again considered here. And he has also right to make complaint about deficiency in services. Perhaps you might have seen about deficiency of services under Consumer Protection Act itself when it comes to doctor-patient relationship, but that's not so. In many of the cases, the patients can't go under Consumer Protection Act because they don't receive the services on payment of some consideration. Then in that case, where should these poor people go? So here, there is such provision also. Then there are separate provisions regarding mental health establishment, about their registration, about audit, inspection, inquiry, the digital register to be kept regarding registration. And of course, they have duty to display about the contact numbers, contact details of the board members. Okay, so with these provisions, of course, with respect to this chapter, I would like to say that the central authority that has been created under this act, they have come up with the rules. especially for such establishment whereby they had laid down the procedures in this regard. Then most important provision under this act, which was not there earlier, it is about Mental Health Review Board. It has provided with all the provisions in that regard. But important for us is that this is a quasi-judicial body created under this act. If you have any complaints or concerns regarding overall treatment of the mentally ill people, or if you find that the rights of the mentally ill people are violated, in that case, this MH Review Board is the adjudicating authority before whom one can apply and get it adjudicated. At the same time, it can inspect the prisons, inspect mental health establishments, and can inquire about the compliance of this law. And of course, regarding advanced directives and all that, this board has got powers. There are extensive provisions regarding admission, treatment, and discharge. How can a person be admitted? How long he be admitted? If he is to be discharged, then how should the discharge mechanism be adopted by mental health establishments? And how that plan has to be managed? There are provisions in that regard. If a minor is to be admitted, then what's the procedure? Overall, how the informed consent is taken up and how important it is, there are provisions in that regard. You can see here, if a minor is to be admitted. Okay, so there are such provisions. For the first time, the Act has come up with a new provision that if a patient is a kind of person where he lives on high support needs, then how long he be kept, when and how such decisions can be taken up. There are provisions. Another one that is important for us as law people is about decriminalization of suicide. That has already been decriminalized by the Supreme Court, and the provisions in that regard have been seen now reflected under Indian Penal Code. The note has been taken, and here a person who attempts to commit suicide is presumed to have mental illness. That is how the provisions are there. Now, this is about the Act. Further, the rules have been framed under this Act. Of course, Act is passed by Parliament and the execution of it is left to the executive. Executive means the concerned ministries. For example, we can say Ministry of Health and Family Welfare comes in this regard. So, in order to implement law, the Act, always the rules are framed. Otherwise, that Act remains on paper. So, likewise, here also the rules came to be framed, and then the provisions have been made regarding halfway homes, hospital and community-based rehab establishment, sheltered accommodation, supported accommodation, and various forms have been laid down under these rules regarding admission, discharge, leave of absence. Rather, the task of the mental health professional is made easy because of such forms being laid down under the Act. Then even the prisoners with mental health, how should they be handled? So there are the rules. Now, here the central mental health authority also is been established by the ministry, and the authority is the statutory authority under Mental Health Act. As it is the statutory authority, it has got power to lay down delegated legislation. Delegated legislation means a lawmaking power is been given to this authority, and in exercise of that authority, the regulations were laid down in 2020, wherein this authority has provided the forms regarding advanced directives. It has laid down the minimum standard facilities and registration procedure for mental health establishments, because the Act always gives the broader picture, and further execution is done by way of rules and regulations. That is how this authority has laid down this part. Then the board meeting. Board means Mental Health Review Board. How frequently they should meet, how should they record their decisions, how should they arrive at decisions. All these provisions have been laid down under these regulations. Then the psychosurgery and restraint, the provisions have been laid down in this regard. And the basic medical records to be provided to persons or nominated representatives. From a mental health professional's point of view, these provisions are important. Okay, I think with this, we stop with the presentation and move on to next part.
Thank you so much.
Yeah, yeah, it might be a little fast, but then the act is very long, so we may better discuss in the discussion part.
Yes. So thank you so much for telling us about the act so much in so much in detail, and it just gives us that the scope of this act. I mean, it's really very broad, considering a lot of things. I remember long ago in 92, as a part of my master's presentation, I had done a presentation on the Mental Health Act of 1987. And now we are in 2017, and it's just amazing to see how mental health, people with mental illness are now having a lot of rights. There are other professions which are being recognized under the act. But as a lot of us who are practitioners, we do come across some issues or some doubts or some questions about what we are doing, whether it is right, whether it's allowed, what are our protections. So these are some of the questions that that come to our mind when we are practicing as psychologists or therapists or doctors or whatever our mental health profession is. So with that in mind, I would like our audience to ask any questions. So please put your question in the chat or raise your hand, and you can ask any questions you would like to ask. We do have some questions, but I'm just asking our audience to first ask any questions that they have in their mind. So let's give them a moment to ask their questions. Anyone? You can raise your hand to ask questions.
Or should we start meanwhile the questions that we have received?
Absolutely, yes, we could do that. So we had asked for some questions, earlier, so we could ask those questions. Just one minute. Yeah. So, yeah, Sheikh Shagufta has raised her hand. Yes, Shagufta, do you have a question? Yes, there are people who are raising their hands. So if you could ask your question, go ahead.
Yeah. Am I audible?
Yes. Akansha, if you can pin the speakers, if they have their videos on, you could pin the speakers, please.
Yes. Okay. So I wanted to ask if ma'am can tell us the exact procedure through which we can get a client or a person facing mental health challenges admitted in a hospital. For a government hospital, like
regarding
if a person is facing mental health challenges, so along with the rights that they have to get admitted in a hospital.
Okay, a person with mental illness to get admitted in the hospital. I think what Shagufta is saying, if I'm understanding right, and Shagufta, you can just tell me that there are some people who are either resisting to get admitted, or family is not admitting them. Is that what you are trying to say?
Yes. So how can we have a procedure for it, keeping in mind their rights?
Okay, a very good question. See, we can look at it from law point of view. The legal principles overall in this regard say that each person has autonomy to decide about whether to take the treatment, whether to refuse it, if the treatment is to be taken, to what extent, from whom, how long. So all this comes under the principle of autonomy, and that is respected by all the jurisdictions across the world. Okay. So if he is ready to take the treatment, we can take him to the doctors, and further regarding his treatment, the doctor takes the decision with the consent of that person. Now here, that consent of that person is considered to be very crucial, because this act is rights-based. Okay, so as it is rights-based, the person has to be respected for the decision that he takes up. Okay, sometimes it may happen, specifically given under the act, that sometimes he may take the decision which is considered to be inappropriate by the others, specifically written. Still, his decision has to be respected. Okay, because this is considered to be the right, and if you don't, then it would amount to violation of that right, for which he can complain to the authority. For example, here it is MH Review Board. Rather, in this regard, I would like to quote one more thing. Ma'am, there is a question raised in this regard about, there is a question I think we have received. It's about what if such covert administration of drugs is taken up. There was such question. Was it in somebody's mind? So what is to be done in this? What is covert administration? For my students who are there from law profession, for them to understand, covert administration is when the medicines are given in a disguise. Okay, without the knowledge or consent of that person. That may be given through food or drink, or not necessarily through food or drink, but through some other, with the help of some other medication, like it may be given by giving injections or by using some other kind of treatment. So what about such kinds of things? Okay, so in this regard, I would like to say that our Mental Health Care Act 2017 is silent about it. So what does it mean? Ultimately, indirectly, we may say that when you are giving any such kind of treatment without his consent, it is a violation of his right. Okay, indirectly, that is the repercussion of it. Whereas if you see some other jurisdictions, like say UK, in UK, there are very well-developed provisions in this. At the same time, they have Mental Capacity Act 2005, by means of which there are certain national guidelines laid down in this regard, whereby it is said that such kind of covert administration can be done in case of a person above 16 years of age. Okay. And when such decisions are to be taken, they have laid down the procedures that though consent is considered to be a basic human right, it can be waived in certain mental health conditions. So the provisions are there. For example, a person is not having capacity to take his decision about how should he be treated. Then in that case, who's to take the decision when there are no advance directives? So can he be administered any treatment without his consent? The answer is given under that act. So they have laid down a procedure, and under that, when it is said that a person lacks in capacity, am I audible?
Yes. Yes.
Am I audible? Yeah.
Yes,
when the person
yes,
lacks in capacity, it is assessed by the mental health professional, and when he is refusing the treatment, the reasons for such refusal are seen and are tried to be addressed. The documentation in that regard has to be kept, and then there is a meeting that is called as best interest meeting that is taken up, in which the concerned doctor, the relative of that person, the other medical practitioner who can decide independently in this regard, they sit together. That is called as best interest meeting, that is conducted, The proceedings are recorded, the decision is arrived at, the reasons for that decisions are recorded, then how it actually that is to be managed, implemented, the management plan is written down, the staff that are going to be involved in administration of such treatment, maybe nursing staff or other paramedic staff who are to be included, they are trained in this regard. The concerned mental health establishment should have a policy framed in that regard, and all that documentation has to be kept. With all that, they can prescribe that authorization.
Wow.
So such provisions are there, which actually, I think, when I objectively look at the act, I would certainly like to say as a law person that, okay, the human rights are recognized, and because law people were involved in framing of the draft of this law. But while taking up such approach, sometimes overstress on such rights can neglect the best interest of that patient. Okay, so I find that somewhere in future, Indian lawmakers also would think of in this way.
I think wonderful.
I think there are now many questions here in the chat box.
Yeah, there are questions in the chat. And I think this is great because you're giving us insights into what other countries have done in terms. And I think there's a great scope for improvement of the act through various amendments, taking ground realities, because we come across people, who probably don't have they do not understand their best interests, and the family is struggling. They want to admit that person in a hospital, and he may say, I don't want treatment. But without, with no treatment, that person is going to get worse and worse. So such things maybe in the future, we can, expect that something is done about that. Here, do we have this best interest meeting happening? Yeah. Do we have this best interest?
We don't have any such provision. Rather, people are not aware about this idea.
So I think here through this webinar, I think we have discovered one area of, maybe an improvement or something that we can do. Mriga is asking, when a person is declared unsound by a competent court, does that declaration have a specific time duration? Wow.
Wow. A very good question. See, when the court declares it, it is for that time being. A person of unsound mind does not necessarily mean that he is living in that state permanently. And that's why any decision taken is prevailing at that point of time. Certain exemptions come only when the person is in that particular kind of condition and commits an act or say an offense. Okay, so it is not universally unsound.
Great. Gauri is asking, how are we going to look over some use of emerging technologies in neuroscience world and some legality towards it?
Gauri is a student of medical technology and law. Gauri, I'll answer this in the class. Okay, but by the way, as others are asking, there are many such technologies emerging in this area. For example, mind hacking, brain mapping. Some chips are inserted into the brain in order to know the functioning of the brain and control the functioning of the brain. Okay, so many such kinds of technologies and medical devices coming up with such kinds of things. And as we know, there are certain medical ethics principles govern such kinds of situations. So far, we are restricted ourselves to Mental Health Act, and Mental Health Act has not taken note of such kinds of technological improvements. Okay, but certainly our ethics theories, okay, especially Beauchamp-Childress theory of principlism, that speak about medical ethics and the principles of autonomy, beneficence, non-maleficence, justice. These principles govern such kinds of situations. And so there is no existing to medical ethics theory.
So as I understand, Jyoti ma'am, these things are covered under the medical ethics part of it, not necessarily the Mental Health Care Act.
Yeah.
Okay,
Of course,
great.
it's a part of Mental Health Act, but it is not today's discussion.
Okay.
Our students keep on working such advancements. So
Right. There were a lot of other questions also, like, for example, what are the rights of mental health professionals? For example, safety of mental health professionals. There may be some people who are being stopped. For example, one of our counselors was, coming up with this question that she feels threatened. The mentally ill person, like she's counseling or whatever, she's being stalked by that person. What do mental health professionals do when they are threatened or such things happen? Or somebody may write a suicide note and blame the psychologist or the psychiatrist for that. So how does the mental health professional respond to this?
Okay. A question, I think we had received that question earlier. Okay, by the way, when we are talking about Mental Health Act, the act is meant for providing the ecosystem, rights-based ecosystem to mental health or mentally ill patients. Okay. Overall, if you see any jurisdiction, I mean any law of the country, you will find that the law has that approach, because who are the most vulnerable? They are considered to be these people. Okay, so in order to protect these people, in order to fulfill the commitments towards human rights of these people, the law has developed. Okay, so if you see in that way, there is no such right recognized for these people under this act. Coming to violation of certain rights of such mental health professionals. Though this act does not address such kinds of situations, there are other existing laws that are equally available to mental health professionals, as are available in case of other general people. For example, somebody is threatening you, somebody is stalking you. There are relevant laws in that regard. For example, there are provisions under IPC Act, there are provisions under IT Act. Okay, and you can appropriately go to concerned authorities, file FIR, and proceed against that. Okay. If somebody writes your name in suicide note, a person, just because he writes something, doesn't support it with the help of evidence. Okay, so all these things are considered if the matters go to court, and there are no separate kinds of rights recognized for any professionals.
Great. Thank you, ma'am. There's one question here from Shilpa. How about a person asking divorce from this serious mental health patient?
Okay, again, a very good question. That comes in our domain. Okay, a person with serious mental health.
She's asked us follow-up question. How about the property sell consent of such patients? So divorce and property.
Okay. Is it coming within the purview of our discussion? If you say yes, I'll answer. It is up to you, being the overall monitor of this session. Should I? Or
yes,
what?
Yes, because
I'll answer in
challenges.
short.
Yeah, please, yes.
Yeah. So suppose a person is having a serious mental health condition. Then in that case, just because he has serious mental health condition doesn't become a ground for divorce. A person should be declared by the competent court to be of unsound mind. Okay. If such declaration is sought and if it is granted, then in that case, it becomes a ground for divorce. Simple. How about the property sale consent of such patient? Okay, a person with mental illness does not ipso facto make him incapable of giving consent. First thing. Okay, he is so incapacitated that he is not able to take or give consent, then only his consent will not be considered to be legal consent. For that, if you want to take his consent, you can get his assessment regarding capacity from the mental health professional, and if he assesses that such person can give consent, then in that case you can record his opinion and take the consent and go ahead for sale.
Thank you so much. I mean, there's such nitty-gritties over here. It's just mind-boggling to know that, you need to know all such things and keep all these things in mind. I think there was one question about how will the Mental Health Care Act change the OPD-based practice for psychiatrists? Any difference in documentation? A role of covert medication, I think, is answered, but does it concern the OPD practice of psychiatrists or anything like that?
Okay. OPD, I thought opinion based. Yes. Now, here, actually, practice will not change. Okay. Because after all, it's the doctor-patient relationship. They would continue to practice their own medical science-related practice. No change in that regard. But yes, regarding consent, they will have to be very particular about keeping the documentation. Okay. Because after all, when it's in OPD, generally what kind of task is undertaken by the doctors, I mean MHPs, is about examination of that patient, assessment of that patient, issuing of certificates, and medication. Such kinds of things are taken up by the MHAs, or I mean mental health professionals, I mean, in OPD. Okay, so they have to keep that documentation ready, because later there can be complications. They may be called in court, because on that basis certain transactions may be taken up by that person, that may be challenged, and in that case the treatment papers will be somewhere submitted. Okay, and they may be called for explanation or opinion and such kinds of things. So documentation matters a lot. Everywhere I say documentation can be your best friend or worst enemy. So you have to be very particular about following SOPs and documentation in that regard. There is one provision that these mental health professionals can keep in mind when this act came to be introduced, Mental Health Act 2017. That is Section 22. Okay, Section 22 is about a right to information. Okay, so this is very important. What kind of information can be sought by these patients? That is important for you. Then there are further provisions regarding the records that may be sought by these people, because it is considered to be the right of such patient, medical records to be produced. And in that case, if he complains that there is some deficiency in service by such people, there can be MH board, review board. So for that, they have to keep all these things in mind. Now, this is about the act. Now, the act, along with act, the rules have been introduced. Just now I mentioned in the slides that Central Mental Health Authority has come up with regulations of 2020. In that, they have laid down 4 kinds of medical records. You may please refer to it. Okay, so what are all those medical records that need to be kept in OPD, and how they are to be given to the persons when he seeks it. So there are provisions, please refer to it, that was never so in the earlier act. Okay, they have even given the pro forma, and now hereafter when you are keeping these basic records, because what is basic record also is explained in these regulations 2020. So please refer to it and maintain those records, and in the pro forma that they have provided. Okay.
Wow. Any other questions? We do have a few more questions. If we can take 5 more minutes, ma'am, is that okay?
Yeah, I don't have any issue.
Okay, so because we had come across, I'm trying to cover those earlier questions that people had sent in. How different is sharing clinical details with insurance companies? Like we keep talking about privacy, but then you need to maybe share information. So what can be released?
I think there are many questions about sharing of data. I think there are many questions about sharing of data.
I think so.
Sharing of data with insurance companies, sharing of data with the relatives of the patient, sharing of data with law enforcement agencies.
Yes.
Okay, when it comes to law enforcement agencies, again, I would say documentation matters a lot. It's very important. First thing that you have to know whether you are capable of, whether you are eligible to practice. Okay, that question may be in the minds of some people. Under Mental Health Act, the professionals are recognized. Okay, if you happen to come in that category, then you are eligible to practice it. Then, of course, you can treat that patient if he comes to you for treatment. And accordingly, you have to keep the documentation. This is one part. Now, second part is sharing of data. When it is about law enforcement agency, what you have to do is you have to ensure that they legally ask for that copies of those documents. Okay, take it in writing, just over the phone, don't share, or don't just send it on WhatsApp or such kinds of sharing mechanism. Keep the acknowledgement with you. Okay, because of so many things involved in this process, see to it that it is done in a genuine way. Okay, when the sharing of data with the parents or the family members of such people are concerned, you have to respect the autonomy and right to privacy of the patient. Without his consent, you can't. You can share it with the nominated representatives only when there are valid legal advance directives, not otherwise. Okay, but there is section 23 under the Act that speaks about rights of the mentally ill patient. That is about confidentiality, right to confidentiality. And they have given certain exceptions in which, without the consent of the patient, you can reveal that information. So, as I said, if there is advance directives and there is not representatives, all this is been done legally, you can release this information, you can share that information to nominated representatives. Then if you want to send this patient to some other mental health professional, okay, then in that case you can share the data. You can share the data with the caregivers if the situation of that mentally ill patient is such that he is likely to cause harm to himself or to some other person who is living with him. Okay, so in such situations, there are 5 exceptions given under that section. In that case, you can share the data. And next is about insurance company. Okay, so in that regard, all of you know that 2020 IRDA, Insurance Regulatory Development Authority, has come up with the directives for all insurance companies to cover mental health. And that's why nowadays many people are coming up with this. You just see again, this thing means you first scrutinize, because the policy, copy of the policy you also get. It's not such a thing that directly insurance company comes to you. Okay, so you see its genuineness and then you can share that.
Wow. I think it's just making us realize that all of us should read that act really well and highlight all those points that we think are important for us and get clarifications from some professionals if we do have any doubts about anything. So any other questions from, from either those? You have covered a lot of it in your, many of those questions which came in, you have already covered. Anyone else, any questions which have not been covered in the presentation or the current discussion? Anyone else wants to ask? Any questions on that YouTube streaming that's going on?
No, so ma'am, no questions there.
No questions there. Okay. Participants, any questions over here? Another few minutes we can, and like I said, we will consolidate all the answers and we will also share with you in the email, everybody who registered. And if you want to share your email IDs, you can share it in the chat here. If you have not registered and joined, and we will also put it on that Facebook Live. We'll go and add those answers there. So everybody has those answers. If you do have a question and it's not answered here, you can also write to us, right? We can we can, write to psychservices@swastivishwa.com or info@swastivishwa.com, and we will answer it. Shagufta, you have another question?
Yeah, I just wanted to ask ma'am that we as aware citizens, how can we contribute and advocate for a more comprehensive act? Like, do we have anything ongoing that ma'am is involved? Like a pressure group kind of a thing wherein we fight for the and give a voice to the voiceless population of us. So is there anything that ma'am is aware about, or we can contribute, form a pressure group, or how can that be?
Yeah, a good question. We recognize many of the rights as a part of human right. And in order to protect the human rights of such people, along with the course, there are many other authorities that are working. For example, we have National Human Rights Commission in India that has remarkably worked for protection of rights of such persons. And taking note of that, we have law in this found that there is human rights violations of any of such category of people that are vulnerable. You just send a letter and NHRC takes note of it. Okay, it's that active. So and you don't have to pay court fee and such things, and very fast decisions are there. People are unaware about such kinds of things. Okay, every time going to High Court and Supreme Court is not possible for a common man. But it is very much possible to approach state human rights commissions, national human rights commissions, where they have a very judicious approach towards handling such kinds of situations. Because after all, the president or chairman of National Human Rights Commission is the retired Supreme Court justice. Okay. And the staff is equally trained. The judges of Human Rights Commission are equally qualified and experienced in this regard. But very few people are aware about such things. Okay, so whenever you find that, okay, such kinds of incidences are happening, you can approach such authorities.
Thank you, ma'am. Thank you so much. There is a question of, Rashmi Joshi is here. Alcohol use disorder. Just one. You want to go ahead and ask your question, Rashmi, since I see you
yes,
on video?
Hi. Nice to see you after so long.
Yeah, go ahead and ask your question.
Am I audible?
Yes, you are.
Yes. So my question to ma'am is that, ma'am, in my experience, I've seen many alcohol use or any substance use disorder patients in severe withdrawal. They were admitted in the inpatient facilities. But when they applied for the insurance, many insurances were declined. So we couldn't, I couldn't follow up further with them, but how can we help them in such cases? Though those are classified under DSM-5 and ICD-10.
So here, what has happened now in India after IRDA has asked the insurance companies to cover these mental health under the insurance cover, they have identified certain common psychological disorders, but they have made two exceptions. One is a psychological disorder or complications arising out of alcohol or drug abuse dependence or withdrawal, and second is self-inflicted injury or suicide attempts. Okay, these two have been kept aside, and the rest of the disorders have been covered. So if that is to be included, you have to advocate for that before IRDA, and because this is a part of their business and they are very much entitled to see as to what should be covered and what not, because they are running the business. So what is to be included and what is to be not. Now here IRDA has directed them that include this. If you want this to be included, advocate for that before IRDA.
Because generally those are comorbid, ma'am, with depression or some conditions, they have that abuse. So can we just not write about the abuse? But not writing the information is also not correct by law.
See,
Majority of
if you
them,
are expecting everything, yes, please.
Majority of them, like for example, they treat their depression by themselves by taking alcohol. So in that there are two disorders which are coming. One is depression and one is alcohol use. So in that case, when it can be given for major depressive disorder, then whether to mention alcohol use on paper, because then if alcohol word is there, then they are
Actually,
declined
so
for the
far,
insurance.
actually, depressive disorders are covered. If that is to be covered, that is what I say, that you have to advocate for that. You create a pressure group, justify it, convince the insurance company as well as the authority that how that needs to be covered.
Okay, thank you
Law
so
is
much.
not a hurdle for all these things.
Yes, thank you so much.
Thank you, Rashmi. That was really a good question, because there are people with comorbidities and all this. Like Shilpa says, even sometimes psychotic symptoms. Yeah, they consume alcohol, substance abuse, all those things can go with, a lot of other disorders. So I guess as a mental health professional, we can see, okay, what is the underlying disorder that we are treating?
Yes.
And if we are treating for depression or psychosis or something, then they will have, but if somebody is coming as an alcoholic, then it may be a different thing. And like Jyoti ma'am said, then advocate for the rights or whatever for those people as well. So I think this discussion is getting very interesting, and but then I think we are running out of our time, and Jyoti ma'am has been extremely generous. I think Amog has asked if this presentation can be shared, ma'am. Is it okay if we share this presentation with our participants here?
Yeah, it is editable, so you have to make some PDF.
Yeah, I will make a PDF, like our team will make a PDF and share it so that it cannot be editable. So thank you so much for this. And please keep those, this one's coming. Meghna, can you just drop in our contacts for everybody so that if there are follow-up questions, sometimes you go back and you think, oh, I should have asked this question. So you could always address those questions to us. We'll pass it on to Jyoti ma'am, get those answers and share them with you all. And with that, I think I will invite Akansha to propose a vote of thanks. And from my side, thank you everybody, each and every person here, and Jyoti ma'am for your extremely valuable time and advice and your presentation. Go ahead, Akansha.
Thank you, ma'am. So on behalf of Swasti Vishwa Institute, I would like to extend my sincere thanks to Dr. Jyoti Bhakare for taking out her time for this very informative session and sharing your knowledge with all of us present here. Thank you, ma'am. I would also like to thank and appreciate our audience present here. Your active involvement and motivation was an absolute delight throughout the session. And a special thanks to Dr. Swati Karve for being a constant motivator and a guiding force to all of us. And last but not the least, I must also acknowledge my colleagues, Meghna and Kalyani, for their unwavering support in making this webinar a success. Thank you for all those who have contributed in some or the other way for a great event.
Thank you so much. It was very interesting and insightful for me too, because we think from one perspective and you think from the other. So yes. I got to know about that as well.
Absolutely. So thank you so much, everybody. And we will keep updating you, the audience here with our upcoming webinars, upcoming events, education opportunities and everything. So thank you so much. And we will see you again soon in another event also. Thank you, Jyoti ma'am. Thank you so much.
Yeah, you are welcome. Thank you, Meghna and Akanksha.
Thanks.
Bye.
Bye.
Thank you, Jyoti ma'am.
Yeah, I take your leave.